Hello and welcome to this video. My name is Bianca and today's topic is called copyright or Urheberrecht. Before we start, the legal information in this video is based on German copyright law called Urheberrecht, but at the end I'll briefly show how it compares to US copyright. And while the specific terms and legal references apply to Germany, the core principles of copyright, such as protection of creative works and the need for permission, are very similar in many other countries, especially within the EU and in countries like the US or UK. Please keep in mind that laws may vary slightly depending on where you live. And this is not legal advice. Copyright law currently includes around 140 to 150 sections, and I do not have formal legal training. All statements made here are without guarantee and based solely on my personal understanding. Now let's start. Copyright simply explained. Copyright ensures that a person's creative work cannot be duplicated, altered, or copied without their permission. In simple terms, that means the creator decides what happens with their work. For example, the creator could say, "I do not want you to use my book or image to make a collage." Important. Copyright applies when a work is duplicated, distributed, or made publicly accessible. In other words, it primarily governs public use. We will look at private use later in this video. Copyright also arises automatically when a work is created. It does not need to be registered or marked in any way. And for the author or the creator is defined as the person who created the work. Protected versus unprotected content. Protection applies to work that meet certain level of originality, called Schöpfungshöhe. Put simple, a triangle, for example, is not protected by copyright because it is a basic, everyday form that lacks creative expression. With hand-drawn images, films, music, or text, the situation is different. And only the specific execution of the work is protected, not the idea behind it. This means you are allowed to draw inspiration from existing works, but direct copies or tracing are not permitted without consent. Special case, public domain content. Works are considered public domain when they are no longer protected by copyright. This happens 70 years after the death of the creator. So if a creator died on January 1st, 1970, the work will become public domain on January 1st, 2041, and will no longer be under copyright protection. CC0 licensed content, Creative Commons 0. CC0 is a specific license or waiver in which a creator relinquishes all copyright claims. The work can be freely used, including for commercial purposes, and without attribution. Now for the key legal sections. Before we'll have a look at the legal sections, again, this is how copyright law works in Germany. In your country, the names and rules may differ slightly, but the ideas are often the same. Now, paragraph 11, Urheberrechtsgesetz. Copyright protects the author's personal and intellectual connection to the work, as well as their right to use it. Paragraph 15. The author has the exclusive right to exploit their work in physical form and the exclusive right to publicly perform or display their work in non-physical form. That means the author alone may decide on all physical uses of their work, for example, printing a book or selling posters, and also all non-physical uses, for example, publishing the work online, streaming it, or showing images. Paragraph 17, right of distribution. The right of distribution includes offering or placing copies of the work into public circulation, meaning only the author or rights holder may decide if and how a work is offered or sold to the public. Paragraph 16, right of reproduction. The right of reproduction includes making copies of the work, whether temporary or permanent, and regardless of the method or quantity, meaning only the author is allowed to make copies of their work. Private versus public use. Privately, you may do as you like with things you have purchased. You are the legal owner and it's your choice whether you cut up, paint over, or collage from your books for creating your desired project. But private use means you are creating something only for yourself. You do not sell it or give it to third parties, and you do not upload it to social media or websites. However, you may not present another person's work as your own or show it publicly without permission. Once you share work online, for example on Instagram or YouTube, you're making it publicly accessible. That's paragraph 19. And that requires the rights holder's consent. What does this mean specifically for crafting? You may use public domain material, CC0 license, content, your own original designs. Everything else, letters, documents, images, etc., is protected by copyright, even if you use original physical pages. If you make a copy of a book page and share it, even as a part of a junk journal, you are violating the right of distribution. And yes, a commercial craft pad filled with detailed illustrations is also protected by copyright, even though it is designed for crafting. It may be used privately, but not shared publicly or commercially. Exception: the manufacturer explicitly allows commercial use, for example via a commercial use license. Conclusion: theory versus practice. This is not meant to scare you or discourage your creativity. As long as you're working privately, there is no legal issue. It only becomes complicated when you show your work publicly or try to sell it. That said, many creators are actually happy when people showcase their products. It's free promotion, but legally it's only allowed with permission. So be careful here. And if in doubt, contact the creator or publisher directly for permission, or stick to clearly permitted materials, such as CC0 content.